One moment, Mr. Bresilla, we'll begin.
Thank you, Your Honor.
All set to go. Good morning.
May it please the court, I'm Attorney Jim Bresilla. I appear on behalf of the defendant, appellant, Alyssa Bresilla. The court has recently heard argument in a handful of cases involving issues of mistaken identification, including recommendations or consideration by the court about adopting portions of your study group, the Eyewitness ID study group. I have cited in my brief as footnote references to several of the recommendations of that study group, but obviously those are not law yet, although I anticipate and look forward to the opportunity of being able to cite those as controlling law, and on both sides of the aisle, pleased to support the efforts being made here in Massachusetts to ensure that finally, once and for all, the scourge of mistaken eyewitness identification does not occur, at least in our Commonwealth here in Massachusetts. The present case gives us another opportunity to participate in that effort.
Could you clarify, before you go on with the identification issue, who it was that identified him? I'm not talking about his jacket. I'm talking about the defendant. Who identified the defendant in court?
There were two individuals. There was Mathurin and Dabadi, Mrs. Mathurin and Dabadi, who were the two individuals who were already acquainted with the defendant before the incident, before the shooting incident.
Right. Dabadi had known him from having seen him at the apartment that the defendant shared, apparently, with the victim.
That's correct.
And Mathui, I'm sorry, how do you pronounce that name?
Mathurin, that's how I
Mathurin.
pronounce it.
Had gone to school with him for many years.
He had said that. Mathurin is the individual who picked out the defendant's photo at a photo array 1 month after the incident.
Right, but he had known him for years before that.
Right.
So on that point, are you suggesting that someone who is already familiar with a defendant, a suspect, is somehow ineligible from participating in a photo array?
Not at all, Your Honor. There is the issue. The issue with Mathurin's photo array is the fact that it took place 1 month after the incident itself.
But if he knew, does the fact that he knew the defendant make a difference in that regard?
To the extent that that would obviously have a factor to consider. If he knew him, depending on how well he knew him, that might compromise the effectiveness of the photo array if he already knew him in the first place. I mean, that would raise the question, why do the photo array in the first place? And that would be a question that the police would be asking ahead of time. Did you know the defendant had prior dealings with him and so forth? I don't know that that was really done in Mathurin's case.
How would they know who the defendant was if it was a blind presenter?
In Mathurin's case, it was a blind presenter, and the questions would be asked.
What question would be asked?
No, I think that your point's well taken, Your Honor. That if it is a blind presenter, you wouldn't be asking how well do you know the defendant ahead of time. No, your point's well taken.
He was still at the time a suspect, right? He wasn't the defendant, was he yet?
No,
I mean, had he been charged by a month after? I just don't.
Yes, he had been.
Oh, he had been.
So, other than that, Justice Lank, no one else identified the defendant at trial.
Right.
The other eyewitnesses were unable, including the show-up ID person, Jacobs.
I take it with respect to the show-up ID, what, did a police officer testify that Mr. Jacobs had identified the defendant at a show-up?
Yes, that did come out, Your Honor.
Mm-hmm.
And Jacobs also so testified at trial, that he
That he
did
had
identify him at
identified
the
someone.
show-up.
The show-up.
But he was unable to, Jacobs was unable, was asked, and he was unable to identify the defendant in trial.
Mm-hmm.
So this case does present an opportunity to continue that effort to address eyewitness identification issues here in Massachusetts. And there were 3 types of identification that were employed by the police. There was a show-up, there were 4 different photo arrays, and the most critical piece of evidence, as it turned out, was the identification of the defendant's jacket. That turned out to be the key part of the Commonwealth's successful prosecution in this case. to a point that the prosecutor, if I may just quote, the prosecutor in his closing, this case is about the civilian eyewitnesses who came into this courtroom and told you, that's the jacket the shooter was wearing. Matter of fact, that's the shooter. That's what the case is about. So that was the critical piece of evidence.
So what were they supposed to do? Go out and find other jackets and line them up in the parking lot for the witness to look at? I don't know what they were supposed to do.
Justice Hines, not in the parking lot, but to put this into context, the problem occurred when the prosecutor was preparing not one, not two, but 3 eyewitnesses shortly before the trial, unbeknownst to the defense. And it was during those witness preparation sessions that Mr. Bhatia, Mr. Mendez, and Mr. Vicini were brought into the district attorney's office, shown a single photograph of the defendant's jacket, and then 3 weeks later identified the defendant's jacket at trial, unbeknownst to the defense.
But Mr. Badia had identified the jacket on the scene that evening, right after the shooting, when
he
the
did.
police officer had discovered it, and he and I think Mr. Mendez were walking back to their cars, and he said that's the jacket that the shooter wore.
Right. That was 4 years earlier.
Right.
Then we have 3 weeks, a short period of time before the trial. Bhatia is then again shown that individual photograph of the jacket, and to prepare him for his testimony, and then comes in and testifies.
But how, let me just ask you this, though. I mean, you don't disagree that preparing a witness is a perfectly legitimate undertaking by the
I
prosecutor?
do not disagree with that at all.
And at least as I read it, the question put with the single photo, agreed, was, do you recognize this jacket, or something to that effect?
That's correct.
So if the police don't know whether X-witness is able to identify the jacket or not, is it your suggestion that, so it seems to me appropriate to inquire about that before the person is on the stand?
Yes.
So what do you think should have happened at that point? They're doing witness preparation.
Let me suggest an alternative, something that was not done in this case. We had, up to that point, at least 7 different descriptions of the jacket being worn by the shooter from several eyewitnesses. And so is it beyond, it's certainly not inconceivable, and I would respectfully suggest is entirely appropriate for during that witness preparation, even before the witness preparation for the district attorney, if they're going to do that, on the conference table in the DA's office, bring in 7 different jackets. A brown bubble jacket, that's not leather.
Yeah, no, I understand. Black leather, et cetera.
There's 7 of them, Your Honor, all different ones, and have them come in and pick it out. If you're going to, but in this case, what the prosecutor did was ignored all the other types of descriptions of the jacket, had a single photograph of the defendant's jacket, showed the 3.
Matter that particular jacket was identified on the scene. I mean, you have somebody who says that's the jacket, and they say that right there after the shooting has occurred, and this person is admittedly a witness to what happened. That's a little bit different from picking a jacket and showing it to a witness where it's never been identified before. Would you agree with that?
Yes, I would, Your Honor, and you're specifically referring to the witness, Bhatia, who did identify the jacket in the parking lot. That was probably close to 4 years earlier, and now is coming in and is going to be asked to identify the jacket in the courtroom.
Saying he doesn't remember the jacket?
We
or
do.
Is his recollection being refreshed? I mean, it's not like they're saying, this is what we have. Can you identify this? I mean, he's already identified it, and it's a question of, does this refresh your recollection?
Right.
So what's wrong with that?
Witness preparation obviously needs to take place on both sides, but what happened in this case, let's focus just on Bhatia. What the defense was not aware of was that the witness preparation occurred at all. The defense was not aware that the witness Bhatia was shown that photograph 3 to 4 weeks before the trial, and then came in and identified the jacket. So the defense did not have the opportunity pre-trial to raise the question whether or not Batia's questioning or identification of that jacket was a product of having seen it 3 or 4 weeks recently, or is he really recalling a jacket that he saw 4 years earlier?
Well, is that an issue of trial preparation? I mean, the defendant's attorney thinking through what goes on in preparation for a trial and filing a motion in limine to sort of suss this out and make sure that everything is on the up and up?
That might have accomplished it, but the defense in this case, Your Honor, had every reason to believe that disclosures like that, call it witness preparation or what have you, would have been disclosed to the defense.
Well, they knew, the defense knew that Bhatia had identified it, correct?
Yes, they did.
So are you suggesting, with respect to him, that it would have been better to do nothing pre-trial, and then presumably by that time the jacket was admitted in evidence because the police officer had it or had already identified it, or it was for ID, and hold up the jacket and say, do you recognize this? Without having had the preparation? Is that what you're saying?
The defense anticipated that there would have been the time lag of nearly 46 months between when Bhatia initially saw the jacket up to the time of trial would raise a question. Let's have a voir dire ahead of time to see if he can really question that. Or in this case, maybe his trial strategy would say, look, I have no idea that he's looked at this at all. I'm going to say last time you saw that was 46 months earlier, 4 years ago. That's subject to cross-examination. That's a wonderful way to impeach him or cross-examine him. That's what the defense anticipated doing.
Yeah, but that wasn't the only evidence there was about this jacket, or who could identify the jacket. I mean, you also had the defendant's sister, who says she bought the jacket for the defendant. And the jacket had also the defendant's DNA on it. The cell phone that was inside the jacket pocket was tied to this defendant's sister. I mean, there was a lot that tied this jacket to the defendant.
Justice Lank, all conceded. There was no dispute that this jacket was a defendant's jacket. The jacket in the parking lot that Bhatia said was the shooter's was the defendant's jacket. What was in dispute is whether or not the shooter was wearing that jacket. And we had several eyewitnesses, at least 7, who had different descriptions of the jacket, including a description that matched the one that was the defendant's jacket. But by the time this trial started, this case stood, as far as the prosecution was concerned, they didn't have just Bhatia prepared to do it. Now they had 3 witnesses, lay witnesses, otherwise completely impartial, who were now identifying this jacket. That became the key part of the Commonwealth's case. There's no dispute that it was a defendant's jacket. That's not the issue. The issue is, was that the jacket being worn by the defendant?
Bresilla, I don't remember this. Did the study group, is there any portion of the study group study that deals with identification of objects as opposed to persons?
There's nothing directly on point having to do with inanimate objects. There is some language in the study group that does talk about attire and apparel, and the importance of attire and apparel to the identification process. This court has recently decided a couple of cases in which it's recognized the importance of attire or apparel to the identification process. Commonwealth v. Franklin, a physical description of the perpetrator or his clothing may warrant certain tailored jury instructions. Most recently, in Commonwealth v. Forte, you sanctioned the introduction and said it was okay to put a video in which the judge also permitted the use of footage from the park for identification purposes, as it would show the defendant at approximately 8 p.m. in attire that matched the recipient witness's description. So attire or apparel is a very important factor. The key case on
Simmons?
is the Simmons case for identification of objects. And Simmons involved a Ford Mustang. So you're not going to have a lineup of Ford Mustangs. And that's clearly...
Do you have a case anywhere where there's a lineup of objects?
Justice Lank, not yet. And there's some that have come close. But I'd respectfully suggest the proposal that I was making before, where in this case, it's certainly not impractical, given the range of descriptions of different jackets here, all by different eyewitnesses, why did the prosecutor eliminate all the others and focus on just the defendant's one and eliminating all the others? Wouldn't we all be more comfortable had jackets matching each of the 7 different descriptions that we have: gray, black, brown, fur collars, no fur collars, leather, unleather, no leather, and identify those? In fact, have it with all the eyewitnesses.
Had either Mendez or
Batia
Vicini
or Vicini?
identified the shooter as wearing a different kind of jacket in on prior occasions? Or
I do not believe so.
So there's nothing inconsistent with them saying that they recognized this jacket?
There's nothing inconsistent. They did not make earlier reports saying, we don't recognize the jacket, or the jacket was this, and now we're saying it's this. So in that regard, we don't have them coming up with a contrary statement that would clearly be Brady material. But what we do have is brand new material coming out 4 years after the offense, unbeknownst to the defense, which was going to clearly be used for impeachment purposes, certainly with respect to Mendez and Vicini, who had never been asked before about the jacket, and now all of a sudden, they're tying it in as strongly as Batia, who just saw it three or 4 weeks before.
Was Mendez with Batia when Batia saw the police officer with the jacket on the ground and say that's the jacket?
I think your recollection is correct in that regard. You can infer from that if Batia said, I saw the jacket, then Mendez would have seen it as well. But isn't it a fair inference also that had Batia seen it, Mendez was an eyewitness known to the police at the time, wouldn't the police have noted that as well? They didn't, which is a fair inference that Mendez didn't see the jacket, didn't pay any attention to the jacket, only Batia did. But again, that was 4 years earlier, and what we have here is the unfairness of singling out all the others for this key piece of evidence, and the defense not knowing anything about it until the 6th day of trial.
Did the cross-examination make it clear to the jury that the different witnesses had identified the shooter as wearing different kinds of jackets?
Could I ask that question again, please, Your Honor? I'm sorry.
Did cross-examination bring out to the, so for the jury to understand that different eyewitnesses had seen the shooter as having worn different kinds of jackets?
I believe there was evidence there was different types of jackets, and the jury may have been known that. But when this case was over and presented to the jury, as far as they were concerned, there was only one jacket and one jacket only that this shooter, whoever he was wearing, and it was the defendant's jacket.
Assuming that it would have been a good, well, my question is, at the time of trial or before trial, is there a particular rule, because the Commonwealth says there isn't, that would have required, this doesn't fit within mandatory discovery, does it?
I would respectfully suggest that it does.
In what way?
The exculpatory, we say it is exculpatory, although we concede.
Exculpatory?
Although we concede that there was not, I'm talking specifically with respect to Mendez and Vicini. Put Batia aside for the moment, who had identified the jacket 4 years earlier. Mendez and Vicini, brand new witnesses identifying the jacket 3 or 4 weeks before trial. We contend that should have been disclosed to the defendant as Brady material. But that, I know the Commonwealth feels otherwise, but if...
How do you get that as being exculpatory?
Because these witnesses now were going to be impeached with the fact that they hadn't identified that at all during that 4 years prior. And so this now became impeachable evidence. And at that point, it became exculpatory. But there was no conflicting reports with respect to Vicini and Mendez. But if it's not Brady, look at Rule 14. Were these identifying witnesses? Certainly Mendez and Batia were identifying witnesses. They were given photo arrays. One said 50%, one said 60%, raises another issue that the study group talks about, whether you use percentages or not. We respectfully suggest there's no room for percentage confidence factors in this kind of evidence. But Mendez clearly was an identifying witness, which would make this mandatory. But even if you don't go there, these witnesses clearly were going to be called as witnesses by the defense. Their statements certainly should have been turned over to the defense, and they weren't.
All right, thank you.
Thank
Your
you,
Honor.
counsel.
May it please the court, Fawn Bolero Anderson from Middlesex on behalf of the Commonwealth, and with me is the trial prosecutor Nicola Lane, or one of the prosecutors rather. This was a strong ID case based on both direct evidence of the defendant as the shooter, as well as indirect evidence based on of the defendant as the shooter. None of those identifications denied the defendant due process of law. First, I'd like to start with the direct identifications of the defendant. The victim was shot on Mass Ave in Cambridge on a March night at 1 a.m. as all the local nightclubs and bars were letting out. Of all the people that were on the sidewalk, 2 of those people were the victim's friends who knew the defendant and identified him by name. The defendant was found by the police hiding in a nearby neighborhood and was the same person that those people had identified by name.
They identified them by name on the scene?
Dabade did, and Matherin didn't.
They said
Police didn't
Elise,
speak with
didn't they?
him for about a month. But they both one spoken to by the police, they both identified him by name. Both of them, Dabade and Matherin, identified the defendant from a photo array in addition to naming him as the shooter.
Right, but the issue is whether, I think, at least the issue that Mr. O'Seal raises is whether, quite apart from that, because of this, the importance of the jacket and the that's the indirect identification, I take it, that there was some obligation on the Commonwealth's part to both do something a little more neutrally than showing a single photograph, and second, provide that information, that identification information to the defendant.
That's correct.
So it isn't so much the strength of the case, it's whether that was required or appropriate, or should it be?
That argument falls under the indirect evidence
Right.
linking the defendant as the shooter. Right now, I'm just dealing with the direct identification, but we can move towards that.
But I guess
Sure.
I am indirectly
be-
asking you to move to the indirect, yes.
Sure. Because there was so much evidence that tied the defendant to the jacket found near the scene, there's no question that it was the defendant's jacket. So as defense counsel points out, it is the identifications that link the jacket to the shooter that make the evidence so damning. However, the defendant spends all his time talking about how key these identifications were to the conviction, but that's not what really matters here. What matters is the suggestiveness of those identifications, the procedures surrounding those identifications, with regard to whether or not the admissibility was outweighed by the prejudice, because this is the Commonwealth submits with regard to identifications of inanimate objects. This is more of a trial issue, a relevancy issue, as opposed to a constitutional-based exclusion. The defendant wants you to think that this was an extreme case because of the significance of the evidence, but that's not what really an extreme case is. If you look at Simmons, an extreme case deals with the suggestiveness surrounding the identification, and I would submit that you would take into consideration both the estimator and system variables that are discussed in the 2013 study group to decide whether or not the suggestiveness of those variables diminish the probative value so much of the identifications that they're no longer admissible because their unfair, prejudicial, and unreliable quality outweighs its probative value. So that's the extreme case that the court is talking about. And these IDs that occurred both at the scene of the jacket and then during the police questioning by Shelley Bresilla, and then the 3 trial prep identifications don't fall into that category with regard to the suggestiveness. So that's the one reason.
So implicitly, you are saying that with regard to non-human IDs, it's a 403 analysis.
That's correct.
And with regard to human IDs, we use a due process or common law analysis.
That's correct. And it's only IDs of defendant where implicate the constitutional protections. And we know that from Spann. Spann was an identification of the victim by a witness, and the court said that that falls into more of the,
But it's identification, direct or, should it be direct or indirect? In other words, the reason this matters is because it's identifying the defendant.
but we know from the plethora of research and science that talks about memory and how that affects a witness's identification of a person based on his or her unique features. It's not identification of objects that matter.
Well, I think the science would say, that the plasticity of memory doesn't depend on whether you're looking at a human or an object, does it?
I think it does. It is somewhat different because if you read the study group, they very much focus on the unique characteristics of a person and a witness's ability to go through the 3 stages of memory with regard to a stranger's image. An image, so it's the person. So there's cross-racial issues that come into play, there's weapon focus, there's all of these different variables that come into play when you are asked to recall someone's image. I think that's different with regard to items. And it's on purely basic common sense that, when someone identifies an object, they're saying, yes, that it looks similar to that, because there's no way of knowing really if it's the same, especially a mass-produced item. I'm using a blue pen today. If you go back in your chambers and you hold it up and you say, yes, that's the blue pen she was holding, it's not necessarily the same blue pen, but we all know as lay people that it's similar to that blue pen. So it's different than identifying a person saying that's the perpetrator, as opposed to saying that's the jacket, because
But that varies by case.
It does vary by
I mean, if you
case.
were to commit a crime, your dress is more singular than your brother's suit. And we have had cases in which the most singular thing about the ID was the unusual clothing of the defendant. So,
Right.
I agree that if it's referring to a men's suit, you may say, well, it's a typical black men's suit, and who can distinguish? But your dress is much more singular, and one can say, I remember that, and distinguish that from what's being worn by your sister to your left.
That's correct, but as we know, there are many similar items, and people know that in their everyday experience, that there's similar items. Even though there's some uniqueness to them, there's many similar items. For example, in this case alone, we have evidence that there was another man walking nearby that had a jacket with fur on it. I think
black
that
nylon jacket. Did they testify that's the jacket I saw, or it's similar to the jacket I saw?
they did testify to that's the jacket the shooter was wearing, but I think that a juror is able to assess that identification different and process it differently. I'm not saying that it's not subject to the relevancy analysis based on the suggestiveness, or that they shouldn't be told how to identify identifications altogether in the jury instructions. What I'm saying is that it's not owed the same constitutional protections as an identification of a defendant based on his unique image. And that's why it falls outside of those protections, and that this wasn't an extreme case, because it was the one-on-one nature of it wasn't more suggestive than a regular one-on-one show-up.
Can I ask you this? I'm looking at Rule 14 and
Yes.
at automatic discovery, and one of its 14(1)(a)(8), a summary of identification procedures and all statements made in the presence of or by an identifying witness. Is that, I don't have the rest of the rule there, is that, is it clear that that's only talking about humans as opposed to something that may play a key role, like a piece of clothing that the suspect was wearing?
Yes, I believe it is. I believe because of the case law that says that only identifications of defendants as perpetrators are owed these protections
But I mean,
that
if
we
you-
all
but
know.
if you have an this is about the identification of the defendant as a perpetrator, so
Indirectly, and I think that that would just open the door to so many, and if the court so decides to interpret it that way, it may. However, it has not to date interpreted it that way. And in fact, Justice Hamlin, in her motion for new trial, said squarely, in her decision on the motion for new trial, said squarely that this did not fall within that provision. And I think that that reflects the way that Section 8 is interpreted by practicing attorneys as well as judges. And getting to the discovery issue, I would suggest that there was no real surprise by this experienced defense attorney that these witnesses would be asked to identify the jacket in court. He found out about this during a voir dire of Mendez. At that time, when it came out,
During trial, voir dire of Mendez?
mid-trial voir dire of Mendez with regard to whether or not he could identify the defendant, and it came out that he was going to be asked to identify the jacket, and that he had been prepared during trial prep by being shown a jacket. This came out during a voir dire. It wasn't in front of the jury. At that time, the defense...
Vicini, had he testified at this point?
No, I don't believe he did.
Okay.
And so when the defense attorney learned of it, at that point, there was no, wait a minute, I don't know anything, I haven't heard about this before. There was no real surprise. It wasn't until the next morning when he filed his motion to preclude the witness from making the in-court identification that he listed both the taint from the pretrial, from the trial prep procedure, as well as the delayed disclosure. And I would say that there was no real surprise here.
But the voir dire itself had to do with Mendez's identification of the defendant, not the jacket?
That's correct. And it just happened to come out during that voir dire that this is how it happened. And I would suggest that conversation that happened between the prosecutor and these witnesses during the trial prep was not something that had to be reduced to writing and turned over pursuant to the rules of discovery. As I already discussed, it doesn't fall under the statement of an identifying witness. It wasn't written down, so there was no statement that was being withheld from the defense attorney, and I don't think it falls within exculpatory evidence where the defendant was put on notice that all three of these witnesses, Bresilla, Mendez, and Vicini, had given detailed descriptions of the jacket. Vicini...
They had given, he was put on notice when?
He was put on notice that they all told police what the jacket looked like.
Before?
Before this, at the time when they were interviewed, Vicini told police that it was a light brown coat with fur on the collar or hood.
And he'd known this in discovery that had been long since provided?
Yes, there was no other issues with discovery. There had been 16 notices of discovery filed in this case. The prosecution team, I would argue, would submit went over and above their obligations.
So in terms of the Vicini and Mendez, their testimony that this was the jacket the shooter wore was not inconsistent with descriptions that they had given in the past, and those descriptions in the past of the jacket had been provided to the defense counsel.
That's correct. So this was just one higher level of inculpability. Not only did these witnesses give good descriptions of the jacket, but they could also identify the jacket that was found at the scene as the jacket that was worn by the shooter, and that's what was not turned over to the defendant. That's that latter part until trial. Vicini said it was a light brown coat with fur on the collar. Mendez said it was a brown leather coat, and Bresilla said it was a big brown jacket with a small fur thing. And he had, as Justice Hines pointed out, had identified that jacket in the parking lot at the night of the shooting. So it's really Vicini and Mendez who had not identified the jacket prior to trial, as far as the defendant knew.
Now, I assume that Cambridge has no protocol for identifying objects.
No, they do not, and I'm not aware of any department in Middlesex that does have a specific protocol for identifying objects.
Certainly, it would be a little bit more complicated to get an array of objects. So you may have many faces in the police department, but you don't have many jackets or photographs of jackets.
Perhaps, but I don't think it's the difficulty that matters here. I think it goes back to saying, when you're identifying an object, you're identifying that it is similar to the same one that you saw, because you can't know for sure that it's the same.
But that's not the question that was asked. It was asked, is that the jacket? It wasn't, is it similar, was it?
I think the question was, do you recognize this? And then the witnesses said, yes, that's the jacket that the shooter was wearing. And I understand that the pure words sound more damning than they really are, because when I identify an object, I can't know for sure that it's the same one because objects are mass produced. the prosecution could have gone out and bought one and said, do you recognize this? And they could say, yes, that's the jacket. And it could be almost identical, and the prosecutor could hold up the jacket found at the scene and this jacket they bought that looks almost the same, and it would have the same effect because of the nature of objects. It's just different.
I think your view of what people think when somebody says that's the jacket and mine are very different. I think if it says that's the jacket, that's what somebody's going to believe, that that person thinks that's the jacket I saw. I don't think you do this mental exercise. No, they don't really mean that. They mean something less.
I take your point, but I just think that a person, based on their unique features of a person's face and appearance, are just much different than identifying a jacket as indirect evidence of identification. When you're identifying a person, it's just based on their unique features as the perpetrator, that it is that, the question of reliability with regard to that we know that there has been mistaken identification cases based on that, and the likelihood of it. So that's the reason why we give those extra constitutional protections for that category of identifications.
So should we be limiting prosecutors' questions to similarity unless there is a voir dire which demonstrates that the witness can do more than that?
I don't think that is necessary based on the common sense of people and their lay experiences. However, it could be, that's why the instructions about identification with regard to eyewitness identification would cover this type of identification, because it's something less than identification of a person. So all the factors that they're told about, their ability to see it and recall and perceive, those all come into play with regard to any type of identification. It's just not the...
Was any kind of instruction specific to the identification of the jackets asked for or given?
There were specific jury instructions requested by the defendant, and in those jury instructions, it was more than is owed, and so I would suggest that there was no error by the judge by not giving those.
What do you mean more than was owed? More than
Was owed. He
required?
was asked to say that an eyewitness identification, the jury instruction requested by the defendant, stated that the eyewitness identification of a jacket or an object is the same as and should be given the same weight as an identification of the defendant. And it's just not the same under the law. He wasn't owed that language. And I think with regard to the cross-examination of the witnesses, all these eyewitness identifications of the jacket, with regard to this strength of the cross-examination and the other evidence of identification, the direct evidence, that the jury jury verdict wouldn't have been any different had he been given specific tailored instructions with regard to those types of identifications.
Let me follow up on that and ask you, the two who knew him and who identified the defendant, Debati and
Matherin.
During their testimony, were they asked to describe what the shooter was wearing?
Yes, they were.
And did they identify the jacket as something he was wearing?
Yes, they were not, I don't believe they were asked to identify the jacket in court because they made in-court identifications of the defendant himself. However, they both gave descriptions of what he was wearing. I can't recall the exact description of the jacket. I know Dabade said that it was a jacket that was previously owned by the victim, so he had some familiarity with the jacket that he was wearing, and I can't recall Matherin. Okay. But where they identified the defendant himself, their descriptions were less important because they knew the defendant prior to this.
No, I appreciate that.
Previously.
So I was just asking if also at trial they had identified what he was wearing at the time of the shooting.
But the sister, it's just a little
It is
there's some
inconsistent somewhat, because the sister does say, I bought that for him, and it also says, I bought the cell phone for him. So it is somewhat inconsistent.
And his DNA was on that jacket.
His wearer DNA was on the jacket. He was found around the corner wearing only a t-shirt, an undershirt. His shirt and his jacket were found in between, on the route where he would have fled between the shooting to the location where he was hiding.
Yeah. And he had gunpowder residue on his hands.
That's correct.
And the shooting occurred in which month?
March. late March. There was testimony from an officer that it was a cold evening and that he had worn his jacket on top of his regular uniform.
All right, thank you.
Thank you.